So the General Data Protection Regulation replaces, in the UK, the Data Protection Act 1998. It sets out in a series of articles the new and revised data protection principles that organisations will need to comply with, and sets out in quite a lot of detail the way in which those principles need to be applied. The other aspects of GDPR which are important and that people need to know about is that it conveys a series of rights to individuals, who are known as data subjects, whose information is being processed, and it also sets out, as well as the obligations on the organisation to comply with the regulation, some penalties that apply if the organisation's getting things wrong. The way in which European law is being transposed into British legislation is that we have to adopt the same rules that apply in Europe as the date we leave the EU. The General Data Protection Regulation comes into effect on the 25th of May 2018, when we're still a member of the European Union, and it will just carry on applying thereafter. The new data protection regime is really an evolution on the existing Data Protection Act 1998. A lot of the principles are fairly familiar, so making sure that your using information in a way which is fair, making sure that individuals know about what information you're using, that information is kept safe and secure, you're not keeping information for longer than you need to, and that you're respecting individuals' rights to ask for a copy of their information. Where GDPR is different is that a lot of the requirements are set out in considerably more detail in the regulation, and there's a lot more emphasis now on show and tell, accountability, being able to show this is what I'm doing with people's information, I've thought about the privacy implications of it, and that I've responded accordingly in terms of the measures that I put in place to keep people's information safe and that I'm using it well. There are a series of what are called legitimising conditions for using information. One of those is consent, another is that it's necessary to use people's personal data in order to do something in the public interest or to discharge a public function. NHS bodies are public authorities, they're doing things for the most part because that's their job, and they're discharging public functions in the public interest. The additional point is that the use of information and personal data for those purposes is absolutely integral. You need to keep records, you need to be able to invite people to come to appointments, and you need to potentially pass on people's information to a GP or to an external provider that's delivering some services to that individual. It's still absolutely possible to do those things under GDPR and to justify it on the basis of those are our tasks, those are things that we're doing in the public interest, and so people will be able to carry on doing those things going forwards. The way in which the GDPR affects existing data protection principles is most importantly what's called the new accountability principle. So at the moment the principles, as we say, are that you need to keep information safe and secure, you need to use information fairly and lawfully, you need to respect individuals' rights to ask for their information. The new requirements are all of those rules set out again, but also that you need to be able to show how you're doing those things. So there's an accountability principle and transparency obligations which are baked into the principles going forwards. The accountability principle applies in a number of ways. First and foremost, one needs to keep a record at an organisational level of the processing that you're doing, so there's a show and tell element that sits within GDPR. You might also need to have some policies. Organisations which are regarded as public authorities for the purposes of the Freedom of Information Act will need to appoint a data protection officer, and so that's NHS trusts, NHS Foundation Trust, but also GP practices, dentists and pharmacists in some circumstances. Similarly, other organisations that aren't caught by the Freedom of Information Act, so for instance, if you're a GP practice but you're not actually a GMS contractor or PMS contractor, will still need to appoint a data protection officer, or at least think about appointing a data protection officer, because the nature of the information that they hold is sensitive, and there is a risk to the rights and freedoms of individuals in terms of that information because of its very nature. So most organisations in the health sphere will need to appoint a data protection officer, and their role is fairly significant in terms of the accountability principle. There's various other ways in which the accountability principle applies. So there's obligations to make sure that you're providing what's called fair processing information to people whose information you're processing. I guess the accountability principle applies in other ways, and as much as you need to cooperate with the information commissioner, who's the regulator, and really be able to, as I say, demonstrate that you're handling information in a way which is respectful, fair, and complies with the principles in GDPR. Transparency is one of the key principles which is made explicit in GDPR. It ties across with the accountability principles, but transparency is dealt with in quite a few specific ways in GDPR. So one of these is the obligation to provide people with what's called fair processing information. So that's information about who you are, what you're doing with their information, how long you're planning to keep it for, who you're planning to give it to, and where that information might end up. That's one of the ways in which the transparency obligation applies, and that also ties across to, as I say, the accountability principle. Transparency also applies in a number of other ways in GDPR. So, for instance, individuals, as I say, have the ability to make what's called a subject access request, so the ability to ask an organisation what information is held about them, and organisations are required to comply with that request within a month in the first instance. Transparency also applies because if you lose someone's information and that has a real risk or a high risk to that individual's rights, and in the case of the loss of large amounts of health information, that could well have a significant impact on people's rights or privacy, there's an obligation to tell them that you've lost their information, and also an obligation to tell the regulator, the ICO. Outsourcing to what's called a data processor, so that's an organisation that's doing things on behalf of the data controller. So a classic example would be a payroll provider or a transcription service. The GDPR says in that set of circumstances you need to have really done some due diligence to make sure that your contractor is as good as they say they are. And also that you have a contract in place with them which sets out a series of obligations which are set out in GDPR that says that the contractor, the data processor, is going to keep not only the information safe and secure, which is the current minimum level of what needs to be in a contract under the Data Protection Act, but also that they'll comply with the other bits of GDPR as well. So there are a series of obligations in what's Article 28 of the General Data Protection Regulation of the things that you need to make sure in your contracts with your processors that are doing things on your behalf. If you're choosing to use a contractor who is outside the European Economic Area, so there is quite a lot of interest now in choosing contractors that might be in India or in other parts of the world that are outside Europe, there are particular requirements to make sure that the contractor in that third country is applying the same rules that apply in the EU, and there's various ways of dealing with that. So there are some contractual clauses that the EU has that says these are the standards in Europe, these are what you comply with, and using those contracts helps to make sure that the data is safe overseas. If you are thinking about getting ready for GDPR, there are a series of things that it's important to do now. Firstly, you need to understand what information you've got, who you're giving it to, what you're using it for, and how long you keep it for. Applying that mapping and then building that into your policies will help to make sure that you're in a good place come the 25th of May 2018 when GDPR kicks in. But I think the other thing that's really important to note is that it isn't a one-size-fits-all single point of time issue. Data protection is an ongoing concept, and one of the things that GDPR specifically says is that you need to keep your processes under review. So someone said recently that GDPR is a bit like having a baby. First of all, you need to deal with the pregnancy bit, which is kind of where we are at the moment, but actually there's bringing up the baby afterwards and making sure that you're keeping your data safe and you're using it well after the 25th of May. And that's important because that helps to ensure that there is trust in your organisation from your customers and from your employees. That probably will give you a competitive advantage, and particularly if you're using information in a way which is efficient. And then the other side of things as well as the carrot, there is also a stick. So making sure that you are being aware of GDPR, that you've embraced the processes that you need to put in place, and that you've given people training and that you've got policies in place is really important, because if things go wrong, and unfortunately things do go wrong, and the ICO come knocking at your door, there is a good story to tell in terms of your general compliance with the regulation, and that will help to avoid enforcement action from the Information Commissioner. One of the things with GDPR is that the level of fines goes up. Lots of people are very worried about that. But the other side of things is that individuals can bring claims against organisations for failure to comply with data protection obligations. The level of litigation around data protection is going up. At the moment, the first group litigation around data protection is going on. And so there is the potential, in the event that you have a data incident which involves lots of your patients or lots of your staff, that it could be pretty repercussive for your organisation and come with a fairly significant financial cost, as well as the resource implications of mopping up. There are a number of different places that you can get advice and support on GDPR. One of the best and simplest and cheapest ways of getting support on GDPR is to have a look at the Information Commissioner's website. They have a series of resources on their website which are geared towards the health sector, but there's also a number of other ways in which you can access resources to support you. The NHS Information Governance Alliance, which manages the NHS Information Governance Toolkit, is starting to put out GDPR resources. You can also talk to consultants or indeed your lawyers if you are interested in compliance issues.